Good afternoon, Sanidhya.
Hello, sir.
Good afternoon, Sanid. All well?
Good afternoon, sir. Sir.
Good afternoon, sir.
Yes,
Good
sir.
afternoon. Good afternoon. सर कब ज्वाइन कर रहे हैं?
Sir, I don't have ideas.
एक बार उन्हें इन्फॉर्म कर दीजिए, कॉल कर लीजिए.
Hello. Good afternoon, ladies and gentlemen. I welcome you all on the behalf of Lex Logical Club, Manipal University, Jaipur, on the webinar on meta-narratives of the Indian Constitution on the occasion of Constitution Day. I would like to welcome Dr. Aditya Pratap Singh, who will throw some light on this topic. He has done MA in Linguistics beside LL.B, LL.M, and LL.D. He has been a JRF awardee in law and is working on semiotic analysis on the basic structures and features of the Indian Constitution. He has been a visiting faculty in Department of Linguistics, Lucknow University, and guest faculty in Applied Linguistics in Mahatma Gandhi International Hindi University, Wardha at its Bhasa Kendra, Lucknow. Dr. Singh was resource person in IPR in Lucknow University LL.B honors course. He served in MMH College Ghaziabad in the capacity of a permanent faculty in law. Mr. Singh specialized in British constitutional law, criminal law, semiotics, semantics, computational linguistics, and media law. Sir, we are glad to have you as our speaker today. Now, without any further ado, I would like you to commence with the session.
Thank you, Mansi. Thank you. And I see Dr. Amit Yadav. My pleasure. And I'm glad you people have invited me for speaking on this Constitution Day.
Thank you, sir. And it's our privilege. And on the behalf of School of Law, Manipal University, Jaipur, sir, I extended my warm greeting and welcome to you, sir. And sir, I am very much thankful that you have spared time for us.
Thank you. Thank you. No, it's my duty. My duty. And today, having seen your university, earlier I had heard about it, but today I explored a lot on Google about your university. It's a happening university and with a very great campus, 123 acres, as I have noticed. That's good. Today, the topic that we have to consider is meta-narratives of the Indian Constitution. That is the theme. But surrounding this, there are many contemporary developments which are happening in our society, particularly in all domains, but with specific focus on legal developments. So I would be talking, besides the meta-narratives, I will also be speaking about the developments which are in the contemporary discussion. So beginning with some initial remarks and things. This year we have got new education policy. And this new education policy, particularly if we look to the legal education, is asking for many contemporary reforms. And these reforms are actually to be online with and in sync with what is happening all across the globe. That's the first thing. And in this regard, the first challenge before the legal education is allowing for some kind of changes in our system, particularly if you look to +2 legal education, that is the LL.B honors type of courses, which come up after secondary education. The new education policy is providing for the multiple entry and exit options. And in this, if we look to the entire span of 5 years of legal education, what we have seen since the first launching of national law universities and 5-year courses, with Bangalore as a crucial experiment way back in 86 and 87. The 5th year is almost with the changes in the last 7-8 years, with honors scheme changing to new syllabus and content. The 5th year is almost a year in waste. Nothing better can be said about it. Because in most of the universities, in 5th year, there are hardly 2 papers taught. And rest of the time, students go for internship inside the campus sometimes, and out of campus in law firms, courts, etc., etc. And these 2 papers can be very safely adjusted in the scheme of 4 years. So what we can do is to minimize this course duration from 5-year law courses to 4 years of legal bachelor's degree. These 2 papers to be adjusted in the remaining 4 years. That way, we are going to make the legal education reaching to the desired and the needy in a shorter framework. This saving of 1 year is crucial because in the present generation, most of the students are asking for an early career settlement. So if we are going to prolong the number of years of bachelor's degree of education, that is not fitted in the futuristic scheme of legal education. So this change, and upon this change, we need some deliberation at national level, squeezing the 5 years to 4 years. That is one thing. Another being that after 3 years, the bachelor's degree may be granted to those who are not desiring for making a career in law profession. So a bachelor's academic bachelor's law degree with the 3 years exit option is another thing which is to be considered by the present policymakers. So if somebody has done secondary and has joined a law course, after 3 years, if one is desiring, one can opt out with 3 years of academic bachelor's law degree and can sit in competitive examinations like civil services, etc., where there is no need of a professional legal degree. These are the options which are to be considered by the UGC, by Bar Council, and other policymakers in the legal education, which is to be now formulated. There's one big opportunity with the new education policy. But yes, definitely these 2 years, 3 years law courses will be in sync with the global practices, the European practices, American practices, where the professional legal degree asks for 1 or 2 additional years to be put in. And for those who are into only academic, they may have a 2 years, 3 years bachelor's degree. That way, our institutions which are in legal education, the private universities, public universities, other institutes of excellence, all have to sit on one platform, and these changes are to be discussed, and accordingly, whatever comes out of this, we can definitely bring this so that the legal education, because most of the students nowadays, after doing science, bio or mathematics, they're opting for career in law. And this career in law, where sometimes academic and other policy issues are to be framed, particularly with developments in science and technology, and how to uh, catch to these developments with a legal policy and regulation. We need now policymakers and thinkers and academicians of a different brand. This is the first dialogue with which I want to begin, and this is very crucial. The second that of the day, that is meta narratives of the Indian Constitution. The topic that I have chosen to speak upon is actually a topic falling at the interface of the Indian Constitution with a new vision and new vision of teaching and learning of Indian Constitution, and the philosophy on which the Constitution is based. To begin with, those who are listening, many may not be acquainted with the terms that I am going to use. And therefore, I'll be initiating a few, micro things about the concepts and the phraseology that I would be using. And these are actually picked up from the domain of philosophy, particularly legal philosophy, and falling at the interface of the modern tools of language interpretation, linguistic interpretation, etc., etc. So let me introduce to those who are students listening me, meta narratives. What is the meaning of meta narratives? Meta means hidden, and narratives refers to the story behind something. So if we talk about the topic, meta narratives of the Indian Constitution will refer to those stories, those interpretations, those uh, uh, what we call understandings of our Constitution, which are not explicit on the surface. They are hidden within the folds, and they are hidden deep inside. So for a common man, these narratives are very rarely to be noticed. So what these features are actually, what the hidden stories, hidden interpretations, hidden philosophies are there in our Indian Constitution, which need to be discussed with the present generation. In the last 70 years, almost after the independence, our Constitution has been taught and learnt in one rhetoric. एक ही शैली में हमारा संविधान और दर्शन अभी तक पढ़ाया गया है. That one rhetoric in which we have learnt our constitution, we have taught the constitution, and the generations have learned the constitution, and the authors have written the commentaries on the Indian constitution. The last 70 years is portrayal of only one rhetoric. And this portrayal of rhetoric actually broadly includes two things. What is written in the constitution and how in the litigation the courts have interpreted and resolved the disputes on constitutional matters. And accordingly, our all authors and great authors from D.D. Basu to H.M. Sirvai to many contemporary, but definitely if I include within contemporary, there are few scholars who have actually worked in some innovative way. H.M. Sirvai was the only thinker in Indian context who, having portrayed Indian constitution in a slightly different rhetoric. Others fall in one genre, one category, that there is something written in the constitution, that the dispute comes before the court and courts have resolved. So in all commentaries of the Indian constitution, you will find the content categorized under three heads. What a particular article and para of it says, what is the dispute, and what the court has resolved. There is no work on what other kinds of rhetoric can be inserted in the Indian constitution. And if we look to American constitution in last 100 years, that is, if I begin from 1930s broadly or 20s till 2020, in the last 100 years, American constitution has been interpreted by the academicians and philosophers over there in a different way. And this different way is, suppose that I pick up a topic that is the basic features and structures of the Indian constitution. Now, what we have done in the last 70 years, from Keshwanand Bharti onwards, after this theory is formulated, the courts in India have only given illustrative examples of basic features and structures of the Indian constitution. Illustrative examples. So, rule of law is a basic feature. Secularism, a basic feature. Judicial separation, a basic feature, etc., etc. Many features are noticed in the constitution, And in all the cases from Keshwanand Bharati till date, there is nothing but citing of illustrations as to what is basic structure and feature of the Indian Constitution. Now, meta-narratives ask for a different policy. And this policy is that how to determine in the Indian Constitution, how to fix in the Indian Constitution as to which feature is to be declared as basic and which as not so basic. Declaration asks for traditional narratives. Traditional narratives are actually the narratives, the portrayals and the stories of the Indian Constitution, the way it has been so far interpreted. This traditional narrative is to be now rejected, and a new narrative has to be devised. This new narrative is to be called a contemporary narrative, a modern narrative, a modern story. And in this, we need to work on two concepts: deconstruction of the old way of looking at the Constitution. And in philosophy, particularly postmodern philosophy, there is a concept of deconstruction. Let us deconstruct the old structure of teaching and learning, and let us invent the new method of looking at and interpreting the Constitution. So deconstruction of the old premises, the old way of looking at the Constitution. And there is another concept in postmodern philosophy that is called reconstruction. So as we deconstruct old houses and reconstruct new with better insights in what we call architectural innovations and skills, we need to reconstruct a new premise altogether, a new structure altogether of the Constitution. So deconstruction of the old and reconstruction of the new is to be done. Now in this slide, if we proceed ahead, let us look to how the basic features and structures of the Indian Constitution can be actually understood. There are three things that I would be placing before you. These are that basic features and structures of the Indian Constitution require three discussions. One is, what are the basic constituents of the basic structure and feature? What constitutes this discussion of the constituent elements is one thing which is required in the present age, in the contemporary age. And our courts, they have a duty, they are duty led and duty bound to get into this discussion as to framing the constituents for calling any feature as basic. So if we go into this discussion, a basic constituent will explore basically the generative factors which give rise to basic structures and features. Generative factors means those factors which, having given birth to these basic features and structures of the Indian Constitution. They will show the factors which shape and modify the basic structure. This is one thing. Then second thing is basic determinants of the structure and feature. So basic determinants, basic constituents is one dialogue, and basic determinants. Basic determinants means what actually determines any feature to call it as basic. So determinants are to be worked out. Then identifiers, basic identifiers. This is the third issue which needs a philosophical search. Identifiers means what features and structures are there in the Constitution and how their sweep can be analyzed and understood. Sweep of a particular structure. कोई भी बेसिक फीचर या स्ट्रक्चर कॉन्स्टिट्यूशन में कितना स्प्रेड आउट है, किन किन आर्टिकल्स में उसका पोर्ट्रेट है, उसका स्वीप क्या है, उसका कैचमेंट क्या है, ये भी एक एनालिसिस की चीज है. अभी तक as we have seen in the last 7-8 decades of our constitutional democratic functioning with the coming of Government of India Act 1935 onwards and with the present constitution after independence, the work in this area is almost not done. That is, neither the courts in India have worked upon the determinants, nor they have worked upon the variables, nor they have worked upon the catchment areas of different features and structures, the sweeping areas, how much quantum of a particular feature and structure is spread out in the text of the Constitution. These things are never noticeable in any discussion, any write-up, any book written by any Indian scholar, particularly reflecting upon and looking at the Indian Constitution from this point of view. If we see the American Constitution, it has gone in terms of philosophical understanding a very thorough change in the last 100 years, from 1920 till 2020. They have explored a lot in terms of philosophy. Similarly, if we ask for that in Indian Constitution, how many features can be said to be part of transnational constitutional features? That is, those features and structures of the Indian Constitution which are transnational in character. Little work is done in this regard. Now, if we look to the traditional method of teaching of Constitution in our university and learning pedagogy from the side of the students, our teaching of the Constitution in Indian universities and the learning of the Indian Constitution in the Indian universities. This actually requires a thorough change. Teaching vision is to be changed. So not only that what is written in the Constitution and how the courts have interpreted, we need to work on what are the hidden interpretations, hidden stories, hidden philosophical narratives in the Indian Constitution. Teaching of this and learning of this requires a communication, a conveyance of thought from the trainers to the learners. Now this two-way dialogue through which the Indian Constitution is to be taught differently and learned differently, that is actually what is to be included in today's discussion that I have formulated, meta-narratives of the Indian Constitution. Now, I have worked a lot upon this in the last 30 years. From the day I started my journey in law, I have worked, but I couldn't spare enough time for writing on this. And in the last 10 years, my health is seriously put in jeopardy because of some liver cirrhosis problem. I couldn't bring it to any kind of, into public domain, my views upon Indian Constitution. But slowly and slowly, the Indian Constitution has to be taught differently and learned differently with modern narratives. And a lot of work is done in US particularly in understanding of the Constitution, in interpretation of the Constitution, and in application of the Constitution. There are many conflict areas in our Constitution which require a new discussion. But definitely some initial dialogue is to be made in our universities, particularly in last 20 years, that is after the coming of Nalsar and other national law universities. The traditional subjects like Constitution, etc., they have been sidelined with the newer subjects like cyber law, intellectual property law, arbitration, mediation, conciliation, and many new subjects are given primacy over traditional subjects which form the foundation of legal learning. And one such area is that constitutional philosophy is altogether sidelined in our national law universities and in private universities as well, picking up lessons from national law university. and many modern institutions of excellence, so-called. They are sidelining the Indian Constitution and philosophy and its importance. This needs a revival. Actually, a package revival is required. Therefore, this much for the day, and I would like to close my discussion today with these, issues being brought to notice of the present generation. Many serious thoughts and deliberations, topic-wise, theme-wise, are to be done. Particularly issues that I have raised. For example, there may be a deep discussion on what is the determinant of the structures and features of the Indian Constitution. What constituents are there? What generative factors are there? And how very little academic, almost no work could be got on syntagmatic and paradigmatic changes in Indian Constitution. Syntagmatic is those occurring at the same time interval, and paradigmatic those which are happening at different time intervals. For example, rule of law as it was in Indian Constitution in 1950 got changed in as it was in 1960. Similarly, rule of law which was there in 1990s got changed, and in present century we are having a different understanding and conception of rule of law. Now, no work is done exploring these different themes, how the rule of law in the Indian Constitution in last 70 years has changed decade-wise. There is no work. You cannot get any such work by any Indian academician, philosopher, thinker, who having worked upon this. Similarly, other features and structures. For example, the understanding of the secularism decade-wise. What changes are there in the Indian Constitution? Witnessed. There is no work. So what we need is teaching and learning of the Indian Constitution in a slightly different way. Our present day generations are to be exposed in a little different way. But this requires definitely trainers are to be actually taught so that they can convey the newer philosophy to the new generation. And we can have a better understanding of our constitution and its philosophy. With these words, Amit Bhai, I seek your permission closing for the day. It was a nice meeting with all of you. Thank you.
Thank you, sir. Thank you so much for keeping insight and basically throwing some light on the road which are less traveled, we must say, in this our constitutional development and Constitution of India. And we all are very much grateful that you have spared your very precious time for us. Thank you so much, sir. And I would like to also extend my greeting to Honorable Director Ma'am, Professor Bhagyashree Sharma, who has given this platform and opportunity to discuss this kind of intellectual. Thank you.
Thank you. Thank you. Thank you all.